Hello, everybody. Happy Thursday. We have a motion to dismiss in the Blake Lively and Justin Baldoni case. You guys, so we are going to have another dramatic law reading here. So grab a beverage. Hopefully you're wearing something very, very comfy. And smash that like, hit that subscribe, and let's get started.
If you like what you see, come and get it with me. I know you deserve all you want, 'cause your heart's made of gold, but don't wait till you're old. If you want it, I get you some.
Hello, everyone. Welcome back to my channel. Pop culture vulture and stand-up comedian Joleen Lunzer here for another No Offense, All Offense, where we talk about pop culture news, trending topics, our favorite reality shows, things we love to hate, things we hate to love. I break it down with a comedic twist. We roast it. We take a look at it. It's levity, nuance. We have a good time over here. If you are joining live, please smash that like. Hit that subscribe if you're not already subscribed. Also, sound off in the live chat. Everything we talk about today, I want to hear you guys' opinions. But just remember, I'm very opinionated. You might not always agree with my opinion. I might not always agree with yours. But as long as we can respectfully agree to disagree, we'll all be okay.
That's my opinion!
Obviously, everything I say today is true, except for the parts that are false. Everything's alleged and for entertainment purposes only.
Allegedly.
Obviously. And good morning to everyone except Tom Sandoval. I honestly thought it was Wednesday today up until this live. So excited to know that it's Thursday and we have an episode of Traitors tonight. So I'll be live after Traitors airs on Peacock, and I'll be doing my dramatic Traitors roast and recap. So hello, everyone joining in the live chat. Good to see you. Good to see you. Okay, so we have ventured into this world of Blake Lively versus Justin Baldoni. And 2 nights ago, into the early mornings, like a day ago, I read what was at the time the newest in this lawsuit complaint saga, and that was Blake Lively's amended complaint. And 6 hours later, we read the whole thing. Those of you who stuck with me, you are amazing. You guys have left such kind comments as well as we do this, and I appreciate you so very much. Okay, let me make sure we got this here. Okay. Oops, I'm on the wrong one. So I appreciate you guys as we continue to cover this. So if you missed that, feel free. If you have an extra 6 hours, if you got to, get some stuff done. If you got a long car ride, you can listen to us break that down. Today, this morning, there is another motion that was filed by Blake Lively's publicist, Leslie Sloane. And she filed this motion asking to be removed from the lawsuit. And so she wrote in the filing, we're going to read the whole thing down, but she wrote in there that she wants to be removed from this. She's asking that, take me out of this $400 million lawsuit that Justin Baldoni filed in January. And attorney Sigrid, is that her name? McCawley filed a motion to dismiss in New York federal court today, Thursday. That's how I was like, oh, it's Thursday, not Wednesday, February 20th, asking the court to remove her clients, Sloane and Sloane's Vision PR firm, from the Baldoni and Wayfarer's countersuit, and she wants them to cover her legal fees. But you know how we do it over here. I want to understand. I don't want to just read. Well, maybe sometimes I will, but I don't want to just read the People magazine things. We want to dig in and we want to read these complaints and these motions, however long they are. I don't know if I got another 6 hour in me, but this one, as opposed to 141 pages, we're looking at 33 pages. So that could be like an hour or so, depending on how dramatically I read it and how much fun we have. You guys know the drill. Like, subscribe, free way to support the channel. If you want to support the channel further, you can always consider joining my YouTube membership. I also remind me, before this ends, I want to buy some YouTube memberships for you guys and gift them to you, but I have to go get my card. So I don't have my purse in front of me. So someone remind me, if one of my mods doesn't mind, I want to buy some because you guys were so sweet and kind to me for my birthday. And you sent me so many wonderful gifts. And you didn't have to, and I appreciate that. And Short Stack just sent me another gift I got yesterday, which is this comfy checkered throw blanket that was on my Amazon wish list. So I want to gift you guys a membership, just like you guys have been gifting in the live chat. I think 2 people gifted last time we were live. They gifted 5 memberships. So I think I'm going to gift 5 or 10 memberships. Short Stack, you're here. I got that. Did I get it yesterday or the day before? I have been cuddling. I didn't even wash it first. Is that bad? It was sealed all nicely. And I've been cuddling with the blanket. And it's so cute. Okay. So I want to gift you guys some memberships at the end of this. If you could remind me, and it's not rude, to put in all caps, Joleen, remember you promised. Because it's like the mom promising to take their kid to Dairy Queen. And then you're like, but mom, oh, I'm sorry, we don't have time anymore. And you're like, I'm going to be in so much therapy for this. So much therapy. Me too, April. A good blanket solves so many problems. Okay. So let's get into it, you guys, and read this. Now, again, I have no law background. So I do appreciate, I have seen some of you come in the comments and be like, Joleen, this is actually this is actually that. And you have no idea how much that means to me that you guys are breaking stuff down and explaining things that I might get wrong, because I'm not a genius like Emily D. Baker. Okay. There can only be one Emily D. Baker. She is not I, and I is not she. All right. So, but you guys are helping me, because I have long wondered if I should try to go back to school and go to law school. Now, I did just turn 45. Not that that's too late. It's never too late. But I may or may not have applied at my local little community college out here to possibly take a couple classes to see if I would be interested. I have a degree a long ass time ago in journalism, and I'm already wanting to be a comedian, or I want to be one. And I think I am one, kind of, sometimes. Stand-up comedy. Yay. But maybe I want to do this, but I also have ADHD. So this just could be a hyperfixation. So I'm keeping my options open, but my husband always says, you'd be a great lawyer, Joleen. And I don't know if that's a compliment or him saying, you sure do like to fight, because I do. So we'll see if this ADHD fixation, or if this is full blown, I need to go to law school, take some paralegal. That's a good idea. That's a good idea. I just have to, my thing is, I just don't think I'm smart enough. And I know that's such a horrible thing to say about yourself, but I feel like I don't think I'm stupid. I think I'm a smart person, but I don't know, not smart enough, I guess. I don't know if I can. It's a lot. It's a lot. Okay. Chickenhead, thank you for starting the live off with the first super chat. Let's do this. So glad you're here today. Glad you got your power back. I saw that you were like, I wanted to be here, but I got my power went out. Okay. So, of course, I don't have my glasses. So I'm going to do the best I can. It shouldn't be that hard. I'm farsighted, but anyways. Okay. So this filed today by Leslie Sloane, Blake Lively's publicist, who is included in Justin Baldoni's $4 million lawsuit. So the plaintiff is Blake Lively v. Wayfarer, blah, 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 boo, boo, boo. Table of contents. We got that going on here. Table of authorities. Obviously, I thought that said Tupac Shakur, but that is a Shakur, but it's a Agnant Shakur. Let's get into it. So I'm going to read. Okay, starting here. All right. Are you guys ready? Grab your beverages. I got mine. All right. Consolidated defendants Leslie Sloane and Vision PR Inc. respectfully, not disrespectfully, respectfully submit the memorandum of law in support of their motion to dismiss the amended complaint for failure to state a claim for attorney's fees and costs, and to strike Exhibit A of the amended complaint pursuant to federal law of civil procedure 12B6 and F, New York's anti-SLAPP. So we hear a lot about the anti-SLAPP law when it comes to these kind of defamation lawsuits. So right away, we're getting an anti-SLAPP. I need a slap. I need a slap sound effect. I did just pound a Celsius, so I'm feeling pretty good. All right. Preliminary statement. Justin Baldoni has spent years profiting off of the feminist and Me Too movements, peddling books, not writing, peddling, podcasts, TED Talks, and more, using slogans, believing survivors, ending victim blaming, and promoting informed consent. His conduct in this dispute is therefore sheer hypocrisy, beginning with his egregious sexual harassment of multiple employees and continuing with his ongoing campaign to discredit and blame his victim and punish anyone who speaks out against him. Now, we know in the filing I read a day or so ago, Blake Lively's amended complaint that she said that it's not just me. She said that there were others. Okay. According to her, obviously we didn't get the names of the others, but it was included in her complaint that they have allowed Blake to share their stories, or paraphrase however she did it, and possibly that they would testify in a trial. Irrelevant Photons, thank you so much for the super sticker. I appreciate you. So here we go. The Wayfarer party's allegations about Blake Lively boil down to she was too ambitious, too outspoken, and she should have accepted Baldoni's bizarre and abusive practices without complaint, no matter how uncomfortable they made her and other women on set. As alleged in Miss Lively's complaint, Baldoni invaded her trailer while she was undressed, improvised kissing scenes without her consent, and repeatedly crossed professional boundaries by showing her a video of a naked woman discussing his pornography addiction and discussing his past sex life, including instances when he did not always listen when women said no. That's in quotes. Unfortunately, Miss Lively was not Baldoni's only victim. Baldoni does not deny the lion's share of misconduct for which he is accused. Instead, he tries to contextualize his behavior and suggest that Miss Lively asked for it. So Leslie Sloane coming out the gate, boom, booyakasha. Let's see. Now, when they say, we know that from, Justin Baldoni, him putting out information to kind of counter this, and through the website he put out and all the text exchange and things that he shared, that this bringing up of showing her a naked woman was actually I believe Mr. Heath's wife giving birth. And then she said, do you have permission to show me this? He said, oh yeah. And then according to Justin, she was like, okay, I'll look at it after lunch. But according to Blake, this was like thrust upon her. Look at my wife's baby door, So, okay. Very dramatic. When Miss Lively bravely spoke up about Baldoni's predatory behavior, he and his team used every weapon in their arsenal to blame, embarrass, and silence her, going so far as to hire a crisis PR management who promised to bury Miss Lively and destroy her life. Baldoni also trivializes this dispute about sexual harassment and retaliation by trying to recharacterize it as a mere battle for creative control of the movie. It ends with us, but it'll never end, it feels like. Baldoni's allegations about the creative issues are irrelevant and tellingly sexist. Because Miss Lively, an executive producer on the film, dared to offer input on the script, wardrobe, and editing, Baldoni blasts her as a tyrannical and aggressive, among other coded terms. The Wayfarer parties dragged Leslie Sloane and Vision PR Inc. into the instant litigation as a smoke and mirrors exercise to distract from their own sexual harassment and systemic retaliation. But the Wayfarer parties never had a Rule 11 basis for accusing Miss Sloane or her company of propagating malicious stories or a smear campaign about the Wayfarer parties. This is like as dramatic as the poetry I used to write as a teenager. Oh, wow. Okay. Other than one New York Times article that they cannot plausibly connect to Miss Sloane or her company in any way, the Wayfarer parties do not identify a single malicious story that is part of their invented smear campaign. By the Wayfarer party's own allegations, all Miss Sloane did was respond to a press inquiry about a story that Baldoni's team seemingly planted. The amended complaint does not and cannot identify anything Miss Sloane did that comes anywhere close to the damning communications between Baldoni and his own publicists concerning an explicit campaign to destroy and bury the woman employee who accused him of sexual harassment. Dying. Okay. The Wayfarer parties accuse Miss Sloane and Vision PR Inc. of extortion, but do not and cannot identify where or how the alleged extortion occurred, or how Miss Sloane or Vision PR Inc. received anything of value because of that distortion or extortion, but sometimes distortion. They also assert claims for defamation without complying with the basic requirement of identifying or describing the statements they allege are defamatory, because the amended complaints scattershot allegations fail to adequately plead claims for civil extortion, defamation, and false light. Miss Sloane and Vision PR Inc. respectfully request that the court dismiss the amended complaint with prejudice and award attorney's fees under New York's anti-SLAPP law. So that is the beginning of this motion that Miss Sloane has put forward to dismiss her and her PR firm from Justin Baldoni's $400 million lawsuit. I'm going to go in the comment section or in the live chat, see what you guys are saying. Let's see. You guys are so cute. I love it. Michelle says, I'm waiting for the camera footage Baldoni hid in his man bun before I decide my opinion. Yep, me too. I'm waiting for all man bun camera footage. Pamela B says, I don't know who to believe. So feel free to sound off in the live chat right now with the things that we know from the complaints and the lawsuit filings, whether you are still on the fence regarding this, because we had so far to go in this, to get to the actual trial. And I know there's a lot of people, public opinion is very much like, no way, Justin Baldoni is being David versus Goliath, bulldozed by this powerful couple. And then obviously you do have people who are like, no, I think multiple things can be true at once. I think Blake Lively could have been sexually harassed. And I also think she could be like an asshole to work with. And there's people, who you're still kind of taking in all the information. We haven't seen proof that in the form of seeing it within the trial of what they're going to show. Obviously, we do have Justin Baldoni and his team and lawyer Brian Friedman. They have put forward a website and text messages, to which Blake Lively says, that's not, all of it. And some of it might be out of, and a lot of people are saying that isn't actually industry standard when it comes to law of how things are presented. And right now, they don't necessarily need to put all of the evidence out front. That happens when they get to trial, which some of you have left in the comment section. I appreciate that. So let me read and see what you guys are saying. Otter says, I don't know enough of the facts to state an opinion. Chris says, who knows at this point? So messy. Chris Ann, yes. April says, they aren't so powerful. Irrelevant Photon says, I do not believe Justin Baldoni deserves to have his life destroyed. Yep, that's a good point. Let's see. Chickenhead says, not on the fence. After reading the legal papers, it's the only stuff that matters. Yeah, that's why I think it's so important that we read these things. And, we'll see as much as, I myself can understand from this. And then when they actually do go to trial, it's fascinating. Pamela says, it doesn't seem like Blake is giving any credible evidence. And again, this could be something that, some of you who are lawyers have said doesn't necessarily have to happen at this stage when filing lawsuits and complaints. The evidence then comes when it goes to trial, when it goes within the court. So Chrisanne says, the truth is a mixture of both. Irrelevant Photon says, Blake destroyed many people's lives. Shine says, I don't know enough facts either, but Blake's accusations seem like Baldoni's a creeper. Michelle says, for years, Baldoni is a creep. And April says, hopefully the confusion will go away once we see the evidence. So not the Pam trifecta. All right, let's get into the factual. Speaking of facts, let's get into the factual background. Oh, we do have Osflager. Hey, Osflager, good to see you. Says, with all the things swirling around, this is a distraction, and I think will change things in the movie industry going forward. Ooh, interesting. Bippity says, correct. The evidence is presented at trial. Because myself, my ignorance to this, and I'll be open to every time I'm ignorant about this, because I don't. Again, I'm not like Emily D. Baker. I mean, she's that. She does the damn thing. She knows the damn stuff. She is a legitimate lawyer, trial lawyer. Like, she knows it. Went to school for that. I'm not going to presume or pretend I am anywhere near that. Okay. I have a journalism degree and I barely use it. I tell, dick jokes with it, but, I really was like, well, Justin Baldoni he's showing so much what appears to be proof, and then to learn that actually at this stage, that isn't necessarily what you have to do or what people normally do. Not saying he can't do that, but some people look at it as a way for Justin to then maybe, him and his team to beat Blake in the court of public opinion. And it's working because, I mean, Blake and Ryan are doing themselves no favors. And from what Justin has released and on this website, because I was talking the other night, I was like, there should be website to website, just go back and forth. But that's the court of public opinion. Now, when it comes to the actual court, that's when we'll see the evidence. So, DC, we have our very own lawyer, DC, here, saying people who are predators tend to hide behind a facade of do good, i.e. R. Kelly in I Believe I Can Fly. Ew. Larry Nassar, hate that guy. USA Gymnastics, or PDF files being teachers. It's hard to know who to believe. Thank you, Jamie B. Yes, hit that like. Yes, Jillian Frogs, Hot Mess Express. Okay, let's get back into the reading, but I love seeing all of you in the live chat. Keep commenting. Thank you so much. Okay, factual background. Miss Sloane is the owner of Vision PR Inc. and the renowned longtime publicist of numerous celebrities, including Miss Lively and Ryan Reynolds. And I think Harvey Weinstein, right? Let me just Google that real quick, but I'm pretty sure Leslie Sloane. Harvey Weinstein. Okay. I know that they were friendly. People are, have alleged that she helped Harvey Weinstein go after his accusers. And then we do have Harvey Weinstein backing publicist Leslie Sloane. And this is from 2014 when she started a new company that will be financed by Harvey. So not good. Leslie Sloane, who is the PR person for Ryan and Blake, was once financed by Harvey Weinstein when she started a new PR venture, allegedly. That's what the Hollywood Reporter is saying. Don't sue me. Don't sue me. Okay. I guess we better hit you with the allegedly. I gotta hit you with the allegedly. Okay. So I'm only bringing it up, Leslie, don't sue me. Okay. Go Mint Mobile. Because they're talking about in this motion to dismiss who she's represented and the celebrities. So she's longtime publicist of numerous celebrities, including Miss Lively and Ryan Reynolds. She has a decades-long reputation for professionalism and trustworthiness. And the Wayfarer party's baseless claims against her have caused her irreparable professional damage and emotional harm. Miss Sloane has never leaked sensitive stories to provoke public controversy on behalf of any of her clients. And the Wayfarer party's attempt to characterize Vision PR Inc. as a Harvey Weinstein-backed PR firm, which is, there's a Hollywood Reporter article saying that. I don't know if it's this company in particular, but in 2014, when you went off into your own venture, that's what it says. So, okay. is intentionally misleading. Vision PR Inc. is entirely unaffiliated with Weinstein, and any stories of the Wayfarer parties have planted or encouraged claiming that Miss Sloane ever worked with Weinstein to attack or discredit his victims are baseless. The Wayfarer parties claim that Miss Sloane initiated the public relations war between the parties and orchestrated a smear campaign against Baldoni. But the amended complaint does not allege any facts to support these inflammatory accusations. Their own submissions, in fact, prove the opposite. Baldoni's PR team began plotting against Miss Lively as of at least July 31st, 2024. And by the end, or by August 4th, his publicist, Jennifer Abel, wrote that she wanted to plant pieces this week of how horrible Blake is to work with. Melissa Nathan, who Baldoni hired as a crisis management expert on the promise that she can bury anyone, responded that she had already, off the record, spoke to the editor of the Daily Mail. Miss Sloane, by contrast, is not alleged to have spoken to the press until 4 days later. On August 8th, 2024, when she responded to the Daily Mail reporter's inquiry. In other words, by the amended complaint's own allegations, Miss Sloane did not speak to the press about Baldoni until August 8th, when she responded to a press inquiry about a story that Baldoni's team planted days, if not weeks earlier. The Wayfarer party's claims against Miss Sloane and Vision PR Inc. appear to arise out of the statements that Miss Sloane allegedly made to the Daily Reporter that she spoke to on August 8th. According to the amended complaint, the reporter asked to speak with Miss Sloane regarding problems on set involving Blake and Justin Baldoni and the fallout over that, with Blake being labeled difficult and a power struggle existing. And Miss Sloane responded, "That is 1,000% untrue, and your info is totally off." Miss Sloane further stated, "The whole cast doesn't like Justin, nothing to do with Blake. And I'm telling you, she's a liar. They are panicking and the whole cast hates him." The amended complaint also includes a screenshot of text messages, which we've seen numerous times between Nathan and the reporter, which were purportedly exchanged following the release of Lively's administrative complaint on December 20th, 2024. In the text, the reporter writes, "She said the whole cast hates Justin. This has nothing to do with Blake, and now she's saying that Blake was sexually assaulted." Why wouldn't she say anything about that then? Miss Sloane did not write the words appearing in these text messages, and the amended complaint does not allege otherwise. Despite including multiple screenshots of text messages written by Miss Sloane, the amended complaint includes no messages where Miss Sloane writes that Blake was essayed or uses similar language. While the amended complaint provides or fails to provide the requisite context for any statements allegedly that could be attributed to Miss Sloane, the only plausible reading of this conversation, which did not include Miss Sloane, is the reporter read the December 20 administrative complaint and was himself characterizing those allegations as Miss Lively being essayed. So legal standard. To survive a Rule 12b-6 motion to dismiss, a complaint must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. And then they have the law that Ashcroft v. Iqbal, or the case, however you would say that in my non-legalese. Okay, legal conclusions are not entitled to any assumption of truth, nor are mere recitals of the elements of a cause of action. When the claims in a complaint have not crossed the line from conceivable to plausible, the complaint must be dismissed. So they're taking this legal standard and saying, since these claims haven't crossed the line from conceivable to plausible, that it should be dismissed. Thus, Leslie Sloane should be dismissed. I'm thinking that's what they are, why they are presenting this legal standard. The complaint must be dismissed. Bell Atlantic Corp versus Twombly or Wombly. Wombly, yeah. So now we have the argument. Wayfarer parties assert claims for extortion, defamation, and false light invasion of privacy against Miss Sloane and Vision PR Inc. Each fails for multiple independent reasons. Okay, the first here. The amended complaint must be dismissed due to impermissible group pleading. As the threshold matter, the amended complaint should be dismissed because it is replete with impermissible group pleading, in that it generally attributes misconduct to defendants collectively, while failing to differentiate between the multiple defendants. The eCheck.com LLC versus NEMC Financial Services Group. Each cause of action is asserted by the Wayfarer parties collectively against the Lively parties collectively. For example, the defamation claim is asserted against all 5 Lively parties, but does not identify the defamatory statements, much less Lively party said them. Miss Sloane cannot be held liable for defamation for statements made by Miss Lively or Ryan Reynolds and vice versa. Nor can she be held liable for an allegedly defamatory article published by the New York Times where she did not even serve as a source. And they tell you to see Rosenberg v. Home Box Office Inc., 2006. Under the New York law, defendants are not responsible for statements that are attributed to a newspaper reporter and that they themselves did not write or publish. The amended complaint also lacks a basic mapping of which Wayfarer party, as a plaintiff, is asserting claims against each of the Lively parties. An explanation of the basis of each party's claims is required, whereas it cannot be that each plaintiff has good faith claims against each defendant. And then they see Aduheen versus City of Hartford, affirming dismissal of complaint due to impermissible group pleading. For instance, there is no viable defamation claim that the Wayfarer parties can assert against Miss Sloane because Miss Sloane is not alleged to have had a single or made a single statement, let alone a defamatory statement regarding anyone other than Baldoni. Similarly, the Wayfarer parties cannot assert an extortion claim against each of the Lively parties when Miss Sloane is not alleged to have received anything of value from any of the Wayfarer parties, and she did not communicate with anyone other than Melissa Nathan. Okay. The amended complaint must therefore be dismissed. Dismissing the complaint that was riddled with instances of improper group pleading in which they refer to actions taken by the Scott Group defendants. Next, the amended complaint fails to state a claim for civil extortion. The civil extortion claim fails for several reasons. First, civil extortion is not a cognizable, cognizable claim under New York law, which clearly applies to the claims against Miss Sloane and Vision PR. Dismissing civil extortion claim because it is not a cause of action under the New York law. They have another case, Murphy versus Kozlowska. So without any analysis whatsoever, the Wayfarer parties assert their claims under California law merely because Lively was contended that California law applies. As to her own affirmative claims, Miss Sloane and Vision PR Inc. do not stipulate to the application of California law as to the claims leveled against them. However, and to determine what law applies, New York courts conduct an interest analysis and apply the law of the state having the great interest in the litigation. Here, New York has the greatest interest in the dispute. The lively parties are all domiciled, domiciled in French. You what the French call les incompetents, domiciled. Okay. And the Wayfarer parties concede that all relevant conduct occurred in New York, and they allegedly suffered harm within, they say. Okay. Let's see. Lots of legal jargon here. So second, if New York were to recognize a civil cause of action for extortion, it must be dismissed as impermissibly duplicative of the defamation claim. The Wayfarer parties do not allege that Miss Sloane engaged in any wrongful conduct beyond making a handful of statements that the Wayfarer parties claim are defamatory. Their claim, therefore, sounds in defamation, and the Wayfarer parties may not circumvent defamation defenses by styling their claim as some alternative tort. See Henjin Chow versus Mount Sinai Hospital, okay, affirming dismissal of tort claims as duplicate, we'll say. Of defamation claim where the underlying factual allegations were virtually identical and alleged underlying harms all flowed from the effect on the reputation caused by allegedly defamatory statements. These are a plethora of cases, so they list more cases, in which courts have found that claims brought under the guise of other causes of action actually sound in defamation, even if the plaintiff alleged economic harm. So third, the extortion claim fails, regardless of whether the issue is controlled by the law of California or New York, because there are federal courts in California which indicate that no such cause of action is available under California law, and the California Supreme Court has not yet determined the issue. Then they have Chevron Corp v. Donziger, and they list some cases here, holding that extortion is only a criminal offense and not a private right of action. They have Arista Records versus Sanchez, 2006, I think. See also Bank of New York. So they list more cases, noting courts are divided over whether California recognizes a civil cause of action for extortion. So a lot of the extortion talk. Fourth, even if the court were to determine that California law applies and follow decisions recognizing a claim for civil extortion under California law, the Wayfarer parties fail to allege the essential elements of that claim. Extortion refers to the obtaining of property from another with this or with his consent. Induced, that's one. Two, induced by a wrongful use of force or fear, or under color of official right. Because extortion is in substance a fraud claim. It is subject to heightened pleading requirements of federal rule, of civil procedure rule. Okay, and they list more cases. So the Wayfarer parties do not and cannot allege that Miss Sloane or Vision PR Inc. obtained any property from them. And even assuming for the sake of argument that a civil cause of action for extortion exists, plaintiff's complaint fails because it does not allege that the defendant actually obtained property from her. And they have more legal jargon there. Dismissing extortion claim where defendant has not alleged that any property was taken for her. Nor do the Wayfarer parties allege that Miss Sloane used force or threats to obtain anything from them. They list a case, dismissing extortion claim where counter claim did not allege wrongful use of force, violence, or fear, and instead merely alleged that plaintiffs informed her of their intent to file the present action, filed the present action, and offered to settle it. In fact, the amended complaint does not allege that Miss Sloane so much as spoke to 6 of the 7 Wayfarer parties: Baldoni, Wayfarer Studios LLC, Jamie Heath, It Ends With Us Movie LLC, Abel, and Steve Sarowitz. And in her limited communications with Nathan, Miss Sloane is not alleged to have said anything improper, let alone threatening. For the foregoing reasons, the court should dismiss the civil extortion claims. So now we have the third here. The amended complaint fails to state a claim for defamation. The Wayfarer party's defamation claim fails on multiple grounds. As a threshold issue, the amended complaint does not and cannot allege that Miss Sloane made a single statement concerning 6 of the 7 Wayfarer parties, which we listed above. Further, all 3 statements that the whole cast doesn't like Justin, the whole cast hates him, and that Blake was essayed cannot give rise to a defamation claim because they are, 1, in actionable opinion, or in the alternative, substantially true. Number 2, not alleged to have been made with actual malice. And we know a lot about, what we do know, I should say, my greater understanding of defamation, which isn't the greatest, we learned from the Johnny Depp Amber Heard trial and defamation. So we do know that they have to, they have to prove, in my layman's terms, that they knew what the information they were putting out was false and that it was done in malice, because then if someone truly believes these things to be true, it's like, how do you prove? That's why a lot of people say defamation lawsuits are very difficult, is because you have to prove malice. You have to prove that people knew, putting out the information, that they knew it was false and did so anyway. And that's my, feel free, legal peeps, to correct me, but that was my understanding when watching Depp v. Heard. So not alleged to have been made with actual malice, and not alleged to have given rise to special damages. The statement that Blake was essayed cannot give rise to a defamation claim for the additional reasons that this statement is not attributable to Miss Sloane. And the circumstances of this statement are not alleged with the requisite specificity. Okay. Miss Sloane alleged statements do not concern 6 of 7 Wayfarer parties. As a threshold matter, the Wayfarer party's defamation claim must be dismissed to the extent it is asserted by Wayfarer Studios LLC, Heath, It Ends With Us LLC, Nathan, Abel, and Sarowitz. So all parties within that. It is axiomatic that to state a claim for defamation, the allegedly defamatory statement must be of and concerning the defamation plaintiff. And this is Kirch v. Liberty Media Group. Whether plaintiff has adequately alleged that the defamatory statements are of and concerning him may be properly considered on a rule motion. And then it says C. Ty v. Kyer. So listing another case here. So many. I mean, this is like, I feel like I'm in law school, but hopefully I'm learning something. Here, the Wayfarer parties do not even attempt to allege a single statement by Miss Sloane that is of and concerning 6 of the 7 Wayfarer parties, and instead allege that Miss Sloane made a handful of statements concerning only Baldoni. Accordingly, the Wayfarer party's defamation claim must be dismissed to the extent it is asserted by anyone other than Baldoni. So basically saying nothing was said about any of the other parties. Just Baldoni is what I'm getting from this. Just keeps reminding, just Baldoni. So statements that a strip club, so here's one. See Three Amigos, SGL Rest Inc. versus CBS News. Statements that a strip club was a mafia enterprise were not of and concerning individuals associated with the club. Oh, interesting. Very Tony Soprano. Statements defaming company were not of and concerning its CEO. And this is also goes back to the case. They say Cardone versus Empire Blue Cross and Blue Shield. Miss Sloane's makes me want to read these cases. Is that, I don't know why I want to do that. Miss Sloane's alleged statements are inactionable opinion or in the alternative, are substantially true. Ms. Sloane alleged statements are inactionable opinion. The Wayfarer party's defamation claim also fails because Ms. Sloane's statements reflect inactionable opinion. Only factual statements are actionable defamation. And they cite Chow v. Lewis in this, another case. Defendants cannot be liable for simply expressing their opinion. That's why we say allegedly, in my opinion, because I don't know if this shit's, what I'm saying is always true. It's like, I hope. I don't know, everything's alleged, no matter how unreasonable, extreme, or erroneous these opinions might be. And they cite Cooper v. Templeton. To determine whether a statement is one of actionable fact or inactionable opinion, courts consider 1, whether the alleged statements have a precise and readily understood meaning. 2, whether the statements are susceptible of being proven false. And 3, whether the context signals to the reader that the statements are more likely to be expressions of opinion rather than facts. And they cite Hammer v. Amazon.com. This inquiry is a question of law. Rappaport, Michael? No. Versus Barstool Sports Inc. 2024. They cite that. Ms. Sloane's alleged statements that the whole cast doesn't like Justin and the whole cast hates him are clearly statements of opinions. They're saying, yeah, she said that about Justin, but that's her opinion. So they're throwing in a Tamra Judge on us.
That's my opinion!
She said, no, I just said that was my opinion. I didn't say that was a fact. Interesting. Okay. Because these hyperbolic personal sentiments are not susceptible to being proven true or false, they cannot be subject to a claim for defamation. And they cite Brady v. NYP Holdings, Inc. from 2022. Holding the term gadfly is, I don't even know what that is an actionable opinion because it is an expression of one's views of another and annoyances to some extent in the eye of the beholder. Caro Cap LLC v. Cook. Same. Holding characterization of activities as incessant malevolence was perhaps extravagant, but an expression of opinion and therefore not actionable. Adler v. Solar Power Inc. 2018. They also characterizing someone as a bad person as a statement of opinion. So in these cases, they cite this one, the Adler versus Solar Power Inc. characterizing someone as a bad person is a statement of opinion. Kearns versus Ishida 208 statements that plaintiff acts like a psychotic nutcase and was extremely unprofessional, had a loose, figurative, or hyperbolic tone, and were grounded in opinion. So breaking that down for us. The statement Blake was essayed likewise amounts to an actionable opinion, given the context in which it was made. As noted above, the amended complaint does not allege what specific words Miss Sloane may have said to the reporter, what date the conversation occurred, or in what context the allegedly defamatory statement was made. To the extent the Wayfarer parties rely entirely on the image capture reproduced at the end of paragraph 193. The phrase sexually assaulted appears to be the reporter's characterization of details included in Lively's administrative complaint, and not any words Miss Sloane ever said. Even if Miss Sloane did use those or similar words, however, where a statement does not appear to be based on any undisclosed facts, but rather offers the speaker's perception of the facts laid out in a public complaint, the statement amounts to an actionable opinion. And they cite Miller v. James, 2024, affirming holding that statements calling a plaintiff a stalker who has committed DV were inactionable opinion because a reasonable viewer would understand the speaker's comments to be conveying his erroneous understanding of the charges described in an article that was simultaneously presented to the audience. Then they cite another case, Brahms v. Carter, where finding a statement was an actionable opinion, where it was clear that the speaker's view that the plaintiff was a quote unquote thief and counterfeiter was based on 2 news articles. So a lot of legal jargon. I do like when they cite these cases though, and maybe that's just my own weird brain. And when they're talking about, like the strip club defamation or lack thereof in these, inactionable, and whether it's just like, someone's opinion based, someone being a stalker, and someone's erroneous interpretation of a news story. So very, very interesting. Or being a thief or a counterfeiter. Right, April? It's a lot. It's a lot. And I don't think we're necessarily, citing all these cases, we're not necessarily, supposed to understand all of this without a law degree, but they are just, citing here's why we think this, and based on other cases and their findings with something similar revolving around defamation. So hopefully, the citations are fabulous. They really are. Even though I don't understand all of them, they're pretty great. They're pretty great. Pamela says, seems like they're going off the rails a bit. So even assuming Miss Sloane used that phrase outside the context of discussing Lively's publicly available administrative complaint and was not merely summarizing what she read or what others told her, the terms essay is insufficiently precise and means different things to different people. So they're saying essay, if that was said, or if that's what the reporter interpreted, that is, it means different things to different people. And they say, see Barber v. Primo, holding the term assaulted is susceptible to a wide range of meanings. Okay. Columbia Health, they cite this. Columbia Health, what is SA? And they provide a link for that. SA can encompass a multitude of forms, such as non-consensual kissing, groping, and or penetration. Courts have been hesitant to apply one definition of a word when there is a colloquial meaning, even if there is also a specific legal or political definition. And that is Miller, 2024. Finding the word terrorist. Oh boy, YouTube is going to be like, demonetize this video with these words. Can be a statement of opinion. Yeah, that could be when people are like, oh God, like a mental terrorist. That person is terrorizing. Even when uttered by Attorney General during a press conference. Well, okay. Because the court is not persuaded that the defendant intended to use the specific legal definition and therefore is not convinced that the language at issue has a precise meaning that is readily understood. Because the text between Nathan and the reporter do not discuss any specific conduct by Baldoni or refer to any specific definition or phrase, essay, as used by the reporter, the phrase has no precise meaning that it is readily understood. So they cite Barber v. Primo, a New York Supreme Court held that a statement that the plaintiff assaulted many people was an inactionable opinion because there is no precise, readily understood meaning of what the speaker may have meant by the use of the term. And it appears on its face to be a hyperbolic phrase, and thus not defamatory. See also Rosa versus Eaton, 2024. Courts have recognized that words like predators, we do hear that word thrown around a lot now, and criminals are vague, imprecise statements of hyperbole considered non-actionable opinion. Springer versus Almontaser, The defendant's statement that she was stalked and harassed was not an actionable statement of objective fact because it did not have precise, readily understood meaning. So objective versus subjective, different meanings for terms. Did that person, mean to use this term in the way in which it is the formal definition? Those are kind of the things I'm getting. Let's hop into the chat, see what you guys are saying. Lucy says, excuse me, did you say let's talk about the husbands? I did see Chell in the chat. Hello, hype man husband Chell, I love you. Irrelevant Photon says, I almost became a lawyer, but I'm so glad I didn't. It's a lot, right? April says, I have nails and I'm not used to typing with them. Oh, no worries. It was an analogy. The housewife's defense. Yes, the Teresa, the Jackie versus Teresa. It was an analogy. And now we have that for Lisa Barlow versus Angie K. When she talked about her husband circle jerking. What if they said that Sean is just circle jerking? Angie K's like, what'd you say? What'd you say? So thank you. Reminder. Thank you for the reminder. Thank you. Keep reminding me. I'm going to star that. So I remind myself. Thank you, graphics. Okay. In the alternative, Miss Sloane's alleged statements are substantially true. So now they're saying in the alternative, okay, Miss Sloane's alleged statements are substantially true. In the alternative, to the extent the court finds that any of Miss Sloane's allegations, alleged, statements are statements of fact, rather than statements of opinion, the Wayfarer party's defamation claim still fails because those facts are substantially true, which is all the law requires. And they say, see Chung versus Better Health Plan. This is from 1997. A statement is substantially true when it has the same gist or sting as the truth, or when, even though technically false, it conveyed the same effect as the literal truth. Interesting. Then they have a case that they're citing, Tannerit Sports LLC versus NBC Universal News Group, noting a plaintiff must plead facts demonstrating lack of substantial truth to survive a motion to dismiss, and affirming dismissal of defamation claim where statements were at least substantially true. They then cite Caro Cap LLC, statement that individual committed felonies that led to his imprisonment was substantially true, even though his sentence was reduced to time served. Chung, 1997, statement that a plaintiff had sexual harassment lawsuit pending was substantially true, even though he had only filed EEOC charge. Interesting. I'm just going to say interesting on that. Here, the Wayfarer parties do not deny the truth of Miss Sloane's alleged statements. So they're saying the Wayfarer do not deny the truth of Miss Sloane's alleged statements, that the whole cast doesn't like Justin. So this comes down to Sloane's statement, the whole cast doesn't like Justin and the whole cast hates him. Quite the opposite. The Wayfarer parties specifically allege that the cast sided with Miss Lively, ousted, shunned, and iced out Baldoni, and even refused to attend the premiere if Baldoni was present. And that'll be interesting to see if there is, I don't know if I've seen any proof to where, or if that'll be presented at trial, to where the other actors have, stated that, whether in text or writing somehow, that they didn't want to attend the premiere if Justin was there. And we do remember that Justin Baldoni was relegated to the basement for his family to sit on the water bottles at the premiere, and he wasn't able to go out at the same time as the rest of the cast when they were on the red carpet for the premiere. So, nor do the Wayfarer parties meaningfully deny the truth of the underlying facts for the alleged statement that Blake was SA'd. For instance, Miss Lively alleges that Baldoni engaged in sexual contact without her consent, including by biting and sucking on her lower lip during a scene in which he improvised numerous kisses on each take. The Wayfarer parties do not expressly deny this conduct and merely argue that Baldoni did not need Miss Lively's permission to improvise because he was purportedly in character, and this behavior was apparently acceptable on the show, Jane the Virgin, which was a show that he was on that I never saw. No offense, all offense to Jane the Virgin, or version. But whether Baldoni believes sexual contact without permission is appropriate in the workplace has no bearing on whether Miss Lively consented to his unscripted advances, which she did not, they're saying. As noted above, it is implausible that the speaker, whether Miss Sloane or the reporter, intended to convey a specific or legal meaning of the phrase essay. But if he or she did, Baldoni's unwanted sexual contacts likely fall within New York court's definition of essay, such that the characterization of Lively's allegation is substantially true. And they cite case C. Morrison v. Scotia Capital, collecting cases and finding the allegations that the coworker caressed plaintiff's foot, and hugged her from behind were sufficient to allege forcible touching, which is one of certain essay claims covered by the Adult Survivors Act. They then cite the case People v. Scene, upholding conviction for essay premised on non-consensual contact between defendant's mouth and victim's neck. Like a damn vampire, okay? Therefore, the Wayfarer party's defamation claim must be dismissed because all of Miss Sloane's alleged statements are inactionable opinion, which they mentioned above a bunch and why, and cited a bunch of cases, or statements of fact that are substantially true. And they say, see, Center for Med Progress, plaintiffs here cannot cherry pick one of several definitions of a word, take the word entirely out of context, and claim that such definition precludes a finding that the challenge statements were substantially accurate. Now we're on to C. The alleged statements concerning essay are insufficiently specific. The Wayfarer party's claim for defamation, to the extent based on paragraph 193's allegations concerning essay, should be dismissed for the additional reason that it is inadequately pleaded. Paragraph 193 of the amended complaint alleges that Sloane escalated the false narrative by telling the reporter that Blake was essayed. As between Sloane and the reporter, however, there is no image capture or representation as to what specific and allegedly defamatory words Miss Sloane said, or when. Instead, the amended complaint merely reproduces an image of an undated conversation between the reporter and Nathan that includes the words, and now she's saying that Blake was essayed. The image of that reporter's text conversation with Nathan, taken sometime after December 20th, embeds an image of his August 8th, 2024 conversation with Miss Sloane, and then describes the fact that Miss Sloane did not mention any allegations of essay during their August 2024 conversation. To state a claim for defamation, purportedly defamatory statements must be identified with specificity. And specifically, a defamation claim must identify the purported communication, as well as who made the communication, when it was made, and to whom it was communicated. They cite another case that was dismissing defamation claim for lack of specificity, because it is entirely unclear whether the reporter is purporting to quote Miss Sloane or if he is paraphrasing or offering his own interpretation of different words that she used, or if the she to whom the reporter is referring is Miss Sloane at all. So they're saying, we don't even know. They say she, they didn't say Miss Sloane. So that they're like, listen, sometimes they said she. Is that Miss Sloane? How do we know? The Wayfarer parties fail to allege with that the alleged falsehood was uttered. And then they cite Riverside, I was going to say Riverdale LLC versus Fuchs. Like, wasn't it John Fuchs from Real Housewives of New Jersey? much less the time, the place, and manner of the allegedly false statement. Oh, is this okay? First Department. Okay. Another case they cite, their defamation claim therefore fails for lack of specificity. They cite another case, so many case citations, where although the plaintiff has alleged in broad strokes to whom the statements were made, unidentified employees, how they were communicated verbally, and when within a 25-day period, this does not suffice to meet the particularity requirement. The particularity requirement. Who knew that was a thing? O'Brien v. Alexander is another case they cite, dismissing defamation claim where complaint fails to allege which false statements were uttered and by whom. So they want to know who, what, when, where, why, how. D, the Wayfarer parties fail to allege actual malice. So now we're getting into the malice portion, which we remember from Depp v. Heard. The defamation claim also fails because Baldoni is a public figure who must plausibly allege that Miss Sloane made the statements with actual malice, and the Wayfarer parties fail to do so for any statement. Individuals who have assumed roles of special prominence in the affairs of society and who have invited attention and comment are generally considered public figures. So they're citing him. He's a public figure. As he admits in the amended complaint, Baldoni was the co-star and director of It Ends With Us, which was one of the year's biggest movies. I think 350 million. Damn. They didn't write that. I added that. He is the co-founder of Wayfarer and has produced and directed multiple films that were meant to have a positive impact on the world. He played the lead love's interest in the television show Jane the Virgin for 5 years. He has a podcast and has written multiple books, and the list goes on. So they're making the case that look at how public he is, even though I had no idea who this man was. No offense, all offense. I did not know who Justin was. I did know who Blake was, and I did know, obviously, Ryan Reynolds. But I did not know who this man was. I apologize. So these allegations are more than sufficient to plead Baldoni into public figure status. Put it in the chat if anyone, and I'm sure lots of people had, it's just my own ignorance. Let me know if you knew who Justin Baldoni was before this, or if you didn't know who Justin Baldoni was before this. Hi, Steven. Good to see you. Smash that like, you guys, if you haven't already. Let's see where our likes are sitting, since this one is a little less fun to read than the other one. And by fun, I mean it's just citing so many cases. Okay. We have 126 likes. That's pretty good. But let's see if we can hit that 200 mark of 200 likes. So Lucy says, no clue. Never heard of him. Esjid said, never heard of him. DC said, I had no idea who he was. Sorry, not sorry. Let's see. April says, bringing up the jersey because I mentioned Fuda. Yeah. I'm not a Tree fan, Teresa Giudice, but Fuda's husband was so obnoxious. Another Louis, he is very obnoxious. Steven said, name sounds familiar, but sure can't say where I'd know that man from. People said, nope, no clue. I did not know about him. Nope. So many people. Irrelevant Photon says, no idea who Justin Baldoni was, but just knew his Jane the Virgin character. I knew about the show Jane the Virgin. I never watched it, but I didn't even know who he was in it. So you guys are all in the same boat as me. Isn't that interesting? I mean, obviously people had to have known who he was because he has this podcast and this platform and he was in shows, but so many of us did not. But I would suffice to say that like most people knew Ryan Reynolds and Blake Lively, you know. Steven he said, no Justins. All Justins are off limits for you. Chickenhead said, I like Jane the Virgin. I heard it was a great show. I just didn't watch it. Beach says, I watched a season of Jane the Virgin. Just my opinion, but I get red flag warnings from him in his fight for women. Feels false to you. Beach says it feels false, maybe performative. I don't want to be defamatory and put my opinion on yours. But Irrelevant said, I liked Blake Lively before this. Jolene, did you listen to Justin Baldoni's creepy, weird voice memo? Yeah, at 2 a.m. That wasn't a good look for sure. their text message exchange that he shared as well, both of them, like, I know you guys have said Brian Bailey says this too, but very creepy actor vibes from both of them. That, like, just weird actor. Like, being in LA as long as I was, a lot of self-importance, a lot of this, they talk like this to each other. But yeah, I did hear that 2 a.m. voice memo. So Shan said they're all running away like rats. Are you talking about regarding Sloane? And then Leotard says, I never heard of him, and I wish I still hadn't. Teresa says, Blake said Woody Allen is all about empowering women. Ugh. And wrote a blog about the allure of the antebellum South. Well, I know I didn't hear about, I know that her and Ryan got married at like one a plantation house. I know that. But I do know that, yeah, so many of these LA people and these actors and stuff are so pro Woody Allen, it's disgusting. And they still do his projects. And it's horrible. That man is disgusting. Jippity Bippity says entertainment lawyer who got tired of people being terrible to each other all the time. Switched to survivors advocate and minors counsel. Happy to help. But Jolene Lunzer, thanks, Jippity Bippity. So you were an entertainment lawyer who got tired of people being terrible to each other all the time. I don't blame you. Switch to survivors advocate. That's beautiful. And minors counsel. Thank you for doing that. Thank you for your service, Jippity Bippity. I'm happy to help. I might Jippity take you up on that if possible. If you can shoot me. I don't know if we DM on the Insta or if you can email me, joleenreacts@gmail.com. But I'm open to, I'll take, any help. And I do like myself some Jippity Bippity. That's very awesome. So, okay, let's get back into this. Thank you guys for your comments. Alrighty. So here we are. All right. It ends with us to have a positive impact on the world. He played the lead's love interest in the television Jane the Virgin for 5 years. That's how we got here. He has a podcast. Yes, has written multiple books, and the list goes on. So they're saying he's a public person, and holding plaintiff was a public figure based on his candid admissions that he was one of the best known writers at Sports Illustrated. This is regarding the case, another case they cited in this. And Margaret versus High Society magazine. This is a case they cited. There is little doubt that the plaintiff, who has starred in numerous movies and television programs over the last decade or so, as the term has come to understand, public figure. So that was cited in that, from that. And Margaret v. High Society mag case. Baldoni is therefore required to plead actual malice to state a claim for defamation. So they're saying he didn't, this is Sloane's team is claiming, no, he didn't state, a claim, or he didn't, didn't plead actual malice to state this claim. And that's what he's required to do. They cite the case Cabello Rondon v. Dow Jones. That is, Baldoni must allege that Miss Leslie Sloane made her alleged statements with knowledge of their falsity or reckless disregard for the truth. So they're saying that, yeah, he must allege that Miss Sloane made her alleged statements with knowledge of their falsity or reckless disregard for the truth. The actual malice standard focuses on whether the speaker entertained subjective doubts about the truth of the publication. And that's, they cite the case Bloom v. A 360 Media LLC. The court may resolve the issue of actual malice as a matter of law at the pleading stage, affirming dismissal of defamation claim where plaintiff allegations fall short of raising a plausible inference of actual malice. So again, lots of talk about, was there actual malice in these things that were allegedly said? The Wayfarer parties failed to meet the high bar to allege actual malice here. The amended complaint is devoid of any factual allegations that Miss Sloane knew or should have known that her alleged statements were false. Miss Sloane was not a firsthand witness of any activities taking place on set, and given Miss Sloane's long-standing relationship with Miss Lively, it is no surprise that she credited Miss Lively's story. Okay. Hughes v. 21st Century Fox. They cite this case here, dismissing defamation claim for failure to plead actual malice and noting defendants' reliance on co-defendants' versions of the events was reasonable given their relationship. So they're saying, since she had this longstanding relationship with Blake Lively, of course she was, going to take her story, credit this, what Blake was saying. I think that's kind of what they're getting at there. Like, it's reasonable to think she would, believe this. And dismissing defamation claim for failure to plead actual malice and noting defendants' reliance on co-defendants' version of the events was reasonable given their relationship. So that is the case that they cited as to their claim that, no, there's no malice. She knew Blake. She's like, it wasn't me. Okay. Of course, I'm going to go with what she says. The Wayfarer parties, conclusory allegation that the Lively parties knew the statements were false or had serious doubts about the truth of the statements is insufficient to plead that Miss Sloane's specific statements were made with malice. See McDougall 489. Particularly considering that by the Wayfarer party's own allegations, Miss Sloane's statements were substantially true. The amended complaint contained no allegations sufficient to allege that Miss Sloane subjectively harbored doubts to the veracity of her statements, much less non-conclusory facts that support the proposition that Miss Sloane knew she was reporting falsities. They're saying she believes Blake. So that's where her opinion stems from, not on any malice or that she's doing this. This is what they're saying. Not that she's doing this because she knows it'll take him down. She believes Blake. They have a long relationship. Mm-hmm. They then cite the case Babalinsky. Ooh, I like that name. Babalinsky versus Tarlov, 2024. Internal citation omitted. Like most individuals accused of sexual harassment, it's no surprise that Baldoni has made every effort to confuse the facts and blame the victim. But his predictable denials, however vehement, are insufficient to support a plausible claim of actual malice. E, we're now already to E. We only have 7 more pages of this. The Wayfarer parties fail to allege special damages. The defamation claim also fails because the Wayfarer parties fail to allege special damages. That is, the loss of something having economic or pecuniary value, which must flow directly from the injury to reputation caused by defamation. And this is where they cite Agnant v. Shakur. To satisfy the special damages requirement, a defamation plaintiff must set forth an itemized account of his losses. They're saying Justin Baldoni would have to have an itemized account of his losses, round figures, general allegations of a dollar amount, or boilerplate allegations of some impairment to business reputation are efficient. These pleading requirements are strictly applied to all courts, or applied as courts will dismiss defamation claims for failure to allege special damages with the requisite degree of specificity. Here, the Wayfarer parties make zero effort to plead special damages. Instead, they offer boilerplate allegations to harm the Wayfarer parties' property, business, trade, profession, and or occupation in an amount no less than $400 million. So they're like, we're going to need to see this broken down. We're going to need to see itemized how we have hurt you specifically $400 million worth against your businesses. This is a textbook example of non-specific conclusory allegations that do not quantify plaintiff's harm with sufficient particularity to identify actual losses, and thus do not come close to meeting the New York standard for pleading special damages. And they cite a case where it says pleading damages of at least $1,990 with no further explanation falls short of the requirement. The unsupported $400 million figure only confirms the deficiencies in the amended complaint. Such round figures with no attempt at itemization must be deemed to be a representation of general charges, and such figures are insufficient to plead special damages for a claim for defamation. They cite a case which states round figures or a general allegation of a dollar amount as special damages will not suffice. They cite another case which says pleading damages in the round amounts of $2 million and punitive damages of $5 million are inconsistent with a claim of special damages. So they cite a few cases here saying you can't do this. You can't just say 400 million, this round number with no itemization, according to them. And these cases. The amended complaint fails to state a claim for false light. The Wayfarer party's false light claim also fails. So they're just breaking down how all of the claims within Baldoni's $400 million defamation lawsuit, why they don't suffice for Sloane. So, and how they are saying they fail. So talk about the false light. As a threshold matter, false light is not a cognizable claim under New York. It must be dismissed on these grounds alone. They cite a case where it says there is no tort of false light invasion of privacy under New York law. Second, the false light claim is impermissibly duplicative of the defamation claim. The false light claim is based on the same alleged conduct and same alleged harms underlying the defamation claim. So it must be dismissed as duplicative. They're like, same. They cite a case which says Condi's claim for false light invasion of privacy fails because no such common law claim exists under New York law. And additionally, any such claim would be duplicative of Condi's defamation claim. Third, the false light claim fails for all the same reasons that the defamation claim fails. They cite a case which says when a false light claim is coupled with a defamation claim, the false light claim is essentially superfluous and stands or falls on whether it meets the same requirements as the defamation cause of action. Fourth, the false light claim fails because the Wayfarer parties fail to allege that Miss Sloane made any statements concerning them that would be highly offensive to a reasonable person, which is an essential element of that claim. They cite a case which says dismissing false light claim for failure to meet highly offensive to a reasonable person standard. That's such an interesting standard. Highly offensive to a reasonable person. What's the definition of a reasonable person? And what's the definition again of highly offensive? Is what's offensive to one and not offensive to another? Is that going to be subjective? Courts have narrowly construed the highly offensive standard. Fair but unflattering depictions are not actionable. They cite a case to this. They cite another case. And they say Miss Sloane made no statements concerning 6 of the 7 Wayfarer parties. So yeah, she talked shit on Justin Baldoni, but she didn't talk about the other 6 of them is what they're essentially saying. She, there were 7 of them and she only talked about 6. That's pretty good. That's what it seems like they're saying here. And her statement regarding Baldoni were made in good faith because like they stated above, she believed Blake. She had a long-standing relationship with her. She didn't think they were lies or malice according to her. And are substantially true. Accordingly, the Wayfarer parties fail to satisfy the highly offensive element. So Miss Sloane and Vision PR Inc. are entitled to attorney's fees and costs. So she's like, you better pay my attorney's fees. You better pay me for my beauty. I think it's only right because I've been paying for it my whole life. Ani DeFranco. Okay. Upon dismissal of the amended complaint, the court should award fees and costs under New York's anti-SLAPP law. The statute applies to claims that, as here, are based upon any lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. They cite a case. That case says the 2020 amendments expanded the scope of anti-SLAPP protection. So the term public interest is a broad, defined as any subject other than a purely private matter. And courts routinely conclude that statements regarding alleged sexual misconduct concern the public interest. They state a case that says courts have found Facebook and LinkedIn posts accusing an individual of SA to be communications concerning an issue of public interest. They cite another case that says the court finds that sexual impropriety and power dynamics in the music industry were indisputably a public or an issue of public interest. So saying this got public interest, by the way. Statements regarding prominent figures like Baldoni also concern the public interest. Under the anti-SLAPP law, fee shifting awards are mandatory, not discretionary, whereas here a lawsuit was commenced or continued without a substantial basis in fact and law. They cite a case, and they cite a law here, New York civil rights law, because the Wayfarer parties' claims all fail as a matter of law. Miss Sloane and Vision PR Inc. are entitled to recover the attorney's fees and costs that they incurred, defending against the Wayfarer parties' baseless claims. And they cite something there that says granting request for attorney's fees upon a rule 12B dismissal and noting the demand for attorney's fees in the present action is thus sufficient to trigger Section 70A1, and she need not file a separate action or counterclaim. Now they cite another case, Trump v. Trump, that says due to dismissal of the claims asserted against them, the defendants are entitled to recover their costs and attorney's fees. Next, the court should strike Exhibit A to the amended complaint. As previewed at the February 3rd, 2025 hearing, the court should strike Exhibit A to the amended complaint pursuant to Rule 12F. The Wayfarer parties filed as an attachment to the amended complaint a 168-page single-spaced document that purports to be a timeline. We remember this. Providing a summarized account of the sequence of key events. Exhibit A is an unsigned, one-sided, factual narrative containing selective excerpts of emails and text messages with numerous redactions and alterations, including text, underlying, and other annotations. So this could, we've heard this from Blake's side, her team saying that all of the proof, the things that Justin and his team showed was one-sided and wasn't complete, and a little bit they feel, cherry-picked, selective, as they put here, which then made them want, years and years of Baldoni's, text messages and correspondence, which some people are like, that's crazy ridiculous to request that. So they're saying there's alterations, redacting email address, identity of signatory and large block text. So Exhibit A should be stricken as it violates both the letter and spirit of the federal rules. Rule 8A requires that a pleading contain a short and plain statement of the claim showing that the pleader is entitled to relief. The principal function of this rule is to give the adverse party fair notice of the claim while avoiding placing an unjustified burden on the court and the party who must respond. They cite a case that says, consistent with Rule 8A requirement of a short and plain statements, courts may not properly consider for their truth statement contained in exhibits attached to pleadings. They cite another case. So this could, also be why they tried to kind of silence Justin and his team from putting out more of this stuff, especially after they put out the website. And like a lot of you have expressed that, releasing this much information into the public isn't necessarily standard practice when it comes to lawsuits and complaints like this. So, I think that it can be argued that that's done to win in the court of public opinion against Blake Lively. And then on Justin's team, it can be argued that is done as a defense because they feel as though they were already attacked and stories put out like the New York Times story with the court of public opinion. So Justin's team is most likely, arguing that, hey, they started this putting out stuff in this New York Times story and the metadata and all that. So we're just putting out our story to counteract that, because if we don't have anything out there, then people are just going to, believe what was put in the New York Times article. That's what I'm assuming they're kind of doing here. Okay. So courts may not properly consider for their truth statements contained exhibits attached to pleadings. They cite a case that says, while Rule 10C provides that a copy of a written instrument that is an exhibit to a pleading is a part of the pleading for all purposes. They cite, I think, a law here that says a personal narrative summary of experiences and events does not satisfy the definition of written instrument. They cite a case that says Rule 10 protects a defendant's entitlement to know the allegations against it and to have those allegations framed in separate paragraphs with sufficient clarity to allow the defendant to frame a responsive pleading. They cite a case. Rule 12F authorizes courts to strike any redundant, immaterial, impertinent, or scandalous matter from any pleading. When a complaint does not comply with the requirement that it be short and plain, the court has the power to strike any portions that are redundant or immaterial. A court may also strike information that is immaterial and irrelevant, such that it has no real bearing on the case before it. And then they cite a case from 2018. As the court noted on February 3rd, 2024 hearing, Exhibit A is almost exactly the type of document that the federal rules are designed to prevent. It violates Rule 8 because it is neither short nor plain. It does not provide fair notice of claims, and it places an unjustified burden on the court and the parties. Because it is not a written instrument, but a personal narrative summary. So they're saying what Justin provided isn't a written instrument. It's a personal narrative summary and fails to provide a mechanism for framing a responsive pleading. So they cite a few other things here, and they say, okay, the law of the circuit is pretty clear that you can't just attach a factual narrative because there's no mechanism for responding to the factual narrative that's attached. In addition, because the court cannot properly consider the information contained in Exhibit A in evaluating the instant motion, it is irrelevant and has no real bearing on the case before it. Interesting. Debbie says, Team Justin. Silly Goose says, so cringe, very cringe. You guys are cringing out. Seeing Things says, I really thought Ryan would settle, but it doesn't look that way. Seeing Things. No, it doesn't. In conclusion, for the foregoing reasons, Leslie Sloane and Vision PR Inc. respectfully request that the court dismiss the claims against them with prejudice, award their attorney's fees and costs under the New York anti-SLAPP law, and strike Exhibit A to the amended complaint. And then it's respectfully submitted. Boyes Schiller Flexner LLP. This attorney, Sigrid S. McCawley, with the signature here. Andrew Vilakasten, Rachel Ruff. They got all the peeps here, and they have the information. So that is, we did it, you guys. We read through another full complaint, another full motion. Very interesting. Definitely more technical than the last one. So let's see how the media, after reading that, is now reporting this. Let's do a little compare and contrast, if you will. So let me stop that share. Let's look at the People magazine story that I was originally talking about in the beginning of this live. We have Blake Lively's publicist asked to be removed from lawsuit, defends actress against Justin Baldoni's sexist claims. Publicist Leslie Sloane's attorney wrote in the filing that Blake Lively bravely spoke up about Justin Baldoni's predatory behavior. Blake Lively and Ryan Reynolds' publicist Leslie Sloane is asking to be removed from the $400 million lawsuit Justin Baldoni filed in January. Attorney Sigrid McCawley filed a motion to dismiss in the New York federal court, which we just read today, Thursday, February 20th, asking the court to remove her client Sloane and Sloane's firm Vision PR from Baldoni and Wayfarer's countersuit and cover legal fees, all of which we read. They were dragged into the legal battle as a smoke and mirrors exercise to distract from Lively's accusations of sexual harassment and retaliation. The filing alleges, arguing there's no basis for accusing Sloane of planting malicious stories or launching a smear campaign about the extortion claims. Sloane's attorneys say Baldoni's lawyers don't identify where or how the alleged extortion occurred, or how she received anything of value because of the extortion, which we read about in just a minute ago. Elsewhere in the filing, Sloane's lawyers defend Lively 37 against Baldoni's framing of the case as a creative struggle to take over It Ends With Us. Baldoni's allegations about the creative issues are irrelevant and tellingly sexist because Miss Lively, an executive producer on the film, dared to offer input on the script, wardrobe, and editing. Baldoni blasts her as tyrannical and aggressive, among other coded terms. They add that when Miss Lively bravely spoke up about Baldoni's predatory behavior, he and his team used every weapon in their arsenal to blame, embarrass, and silence her, going as far as to hire Crisis PR, who promised to bury, quote unquote, Miss Lively and destroy her life. Attorneys for Baldoni did not respond to people's requests for comment. I'm sure they will have a response to this. I assume Brian Friedman will have a response to this. This week, Lively filed her amended complaint. That was just a couple days ago. That was literally 2 days ago, you guys. Updating her December lawsuit against Baldoni, producer Jamie Heath, Wayfarer Studios, its co-founder Steve Sarowitz, Baldoni's publicist Jennifer Abel, Crisis publicist Melissa Nathan, and her company, the agency PR, plus Jed Wallace and his management firm Street Relations. We read a lot about Street Relations in the last one, and that Texas agency group with Jed Wallace. The actress accused them of sexual harassment and retaliation, alleging they orchestrated an online smear campaign to ruin her reputation after she reported misconduct. Her amended complaint alleged that Baldoni 41 made two other unnamed female co-stars uncomfortable, and they are willing to testify against him. And we read that in that 6-hour amended complaint. And I should say it was only 6 hours because that's how long it took me to get through it. But that they were not named. And it did say that they would be, Blake Lively in her amended complaint did say that they'd be willing to testify. The trial is scheduled for March 2026. Let's hope they speed this up. I don't know. Another year of this? Jeez. I don't know. That seems like a long time. Baldoni's lawyers have called Lively's claims false, outrageous, and intentionally salacious with an intent to publicly hurt. In addition to Sloane and her firm, they're countersuing Lively, her husband, Ryan Reynolds, and the New York Times, alleging defamation and extortion. Lively's lawyers previously called the lawsuit desperate and meritless. In Baldoni's amended complaint, which his team published to the masses on their own website, his attorneys claimed he was targeted in an actual smear campaign that was orchestrated by Leslie Sloane at Lively's direction. They further wrote that Sloane, whose other high-profile clients include Lindsay Lohan, Katie Holmes, and Chris Rock, is a master practitioner of the dark arts of public relations, not the dark arts of public relations. What in the chilling adventures of Sabrina are going on here? And led to an intricately planned character assassination plot. In one alleged text message exhibited in Baldoni's complaint, Sloane wrote, I am not paid to take people down. I'm honest. All right, let me hop into the live chat and see what you guys are saying after we read through that. What are you guys thinking? Silly Gooses, forget it, Leslie. If we have to go through it, so do you. Yeah, right? How she's gonna, I lip sync my teeth. She's gonna get out of it. We can't get out of it. Are we gonna talk about the husband tomorrow? Yes, we have to talk about the husband tomorrow, Kathy, because it's Friday. I literally thought today was Wednesday, so. What have I been doing? I don't know. Where is my mind? Judge Joleen needs to tell Leslie Sloane. Denied Leslie. Well, I wonder if she's going to be able to get this dismissed. I don't think so. I mean, what do I know? But we can get a ruling on Judge Joleen.
Who is she? Who is she? Who is she? Where did you find her?
No, Judge Joleen was out in full force during Amber Heard, Johnny Depp, so denied. Leslie Sloane denied. We have decided if we have to go through this, so do you. Judge Joleen has ruled. All right. Maybe people will take me seriously. No, I don't want people to take me seriously, but if I hold my gavel, possibly. Let's see. Teacher B says, cannot wait to hear Brian Friedman's POV on this. I'm sure it's coming soon. Irrelevant Photon says she did it to herself, though. Wasn't that her promoting her own booze line for a DV movie? Oh, that was bad. Yeah, I don't know who approved that. That and the Blake Brown hair care. Again, it's like we understand, multiple things can be true at once, but that was pretty bad. That was pretty bad. Miss Sloane, the answer is see you on court TV, even though we won't because it can't be. I think because it's a federal case similar to Diddy, not that it's the same case as Diddy, but being federal, they can't air that like they did with Johnny Depp and Amber Heard, I believe, because it was civil, not federal, and it was in what state was it? Did they have it? It wasn't Washington? Where was it? No, it wasn't in DC, which I know is not state. But somewhere on the East Coast. Seeing Things says she basically told us who they are, though. Jen Slate and the younger Lily. Kitty Got a Tongue says if she ever gets a role made from a book again, it should be her contract to read it. She must sign the contract before this project starts. I think just reading, the project that, if you're doing a project based on a book, reading it is very helpful because there are quite a few things within this back and forth lawsuit, public discourse of where people are like, no, that that was true to the book, or things they obviously had to change due to Blake's age and stuff. But had she read the book, it's never a bad idea to read the original works on which the thing you're starring in is based on. So I think that's a good tip. All right. Irrelevant Photon says she should avoid movies that involve romance and that kind of stuff. Yeah, silly goose. The dark arts. Thank you. Reminder 5. Graphics, you're the best. Where did you find it? Where did you write? Did you miss the gavel? I have too. It's been back on my shelf. Where are your florals? Another miss. Can't wait to watch Traders, right? Okay. I am going to be gifting. Don't go anywhere, you guys. I'm going to be gifting some memberships. So I'm going to go get my wallet. And in the meantime, the in-between time, if you guys could hit that like if you haven't already. And if you could enjoy this throwback commercial break. Now make sure your account on YouTube, you have it selected to where you accept gifted memberships. I know somewhere in your profile here on YouTube, you can select that. And we have a lot of people who very kindly gift memberships on this channel. So make sure that's open so that when they are, you are in the running. Now, what YouTube does when memberships are gifted, which I'm about to do, is they randomly select you. So there's no way. I think they can even randomly select people who aren't here. But I'm not 100% sure on that. So make sure you have that selected and hit the like, and I'll be right back.
Welcome to Goth Talk. I'm Cersei Nightshade.
And I'm Azrael Abyss, Prince of Sorrow.
Tonight, we're coming to you live from Suncoast High School, where just down this hall, the pathetic day dwellers of the class of 1998 are celebrating the tawdry amusement known as the prom.
Yeah, we'll be great, we'll be awesome, we'll knock him dead, right? Right? Yeah!
This is wrong.
What?
You. Doing my homework, it's wrong.
Well, I was just trying to help.
It's like I'm taking advantage of you or something.
You're not taking advantage of me.
The square of the hypotenuse of a right triangle is equal to the sums of the square of the other two sides, baby!
It would be different if we were like... But now, we're just... You know... a friend or whatever.
No time! There's never any time! I don't have time to study! I'll never get into Stanford! I'll let everyone down! I'm so confused!
I can't do this anymore.
It's okay.
You're right.
It's okay.
Everything will be okay.
Yeah.
I just need one of these.
Pills? You mean you really are taking drugs?
No, in a way it was wrong, but I just have a feeling that this is going to be really good.
I don't know.
So whoever's going to tutor you, their name is next to yours.
Brain Krakow?
Are you... Brain?
Brian.
I need them.
Jesse, give me those.
I need them back. I have to sing.
Jesse! You can't sing tonight.
Yes, I can. I'm so excited. I'm so scared.
So, anyway, The Odyssey is like this real long book, right? And
I don't believe this. I don't... You like do this? This is like how you live?
Yeah.
Hey. All right. Hopefully you guys hit that like. We have 175 likes. Let's see if we can get 200 likes as we're here. Okay. I am going to be gifting 10 memberships and get my little debit card here. So this will again be, you'll be randomly, oops. All right. Did it go through? It didn't have me put in my information. Okay, I guess it just had my information. I'm like, did it go through? Did it go through? Did it go through? Okay. So congratulations, Lucy Furious, Lola at Heart, Judy SG, Sandy, Albino Moon Gal, Irrelevant Photons. Let's see, Cassie Face, Beatrice Hernandez, Taylor Webb, so many people I recognize, Tamara, Stacy Ann Relvini, and I think, is that 10? Hopefully. So it worked. So congratulations, you guys. I highlighted my own. I gifted 10 memberships. You're so welcome. You guys are so appreciated. I appreciate you guys so very much. Again, thank you for all the love you've shown me on this channel as we work our way to 50K subscribers. I mean, we're at almost what are we at? Like almost 43,000 subscribers, I think. So we're on our way to 50K. That's our goal for 2025. And I think we can get there. I think we can. And you guys are amazing. So if you got a free membership, now you have access to emojis here on YouTube, which I do have to get those updated as well. But we do have some fun ones on there. And then you also get bonus exclusive content that you can check out. So you can just go to the membership tab on YouTube on my profile, and you can see things that you get, little perks, if you will. And there will be more members only type things happening soon. I know Steven, the wonderful Steven, and I were doing members only on Mondays. And like we were like every other Monday, and Steven was joining us for a lot. And Steven is just a delight and a treat. So I do think I want to start doing that again and talking about stuff. And it's just where we can kind of let our hair down and have some fun. So Jibbity Bibbity, here is, I'll put the email for you in the chat. So you can email me and then again, anyone is welcome to email me here. JoleenReacts@gmail.com. This is a great place to send me things. I know a lot of you are so great about sending me stories you want me to talk about, or things you want me to look into that we can cover on the channel, that we can roast, so we can recap. So you can send those things to JoleenReacts@gmail.com. Shout out to all my super chatters today: Chickenhead, PK, Dorkface, Neely, Irrelevant Photons, and me for the 10 gifted membership. So you guys are amazing. I will be back later after Traders to do a full roast and recap, because again, Jolene, it's Thursday. Thank you guys so much for joining. And I appreciate you. Smash that like if you're not already. Follow me on social media at JoleenLunzer on Instagram, TikTok, and the Twitter, because it'll never be X to me. And like I always say, you guys remember to enjoy yourself, because it's later than you think. Bye.